Good evening. Today I'm very punctual and I am starting with the brief recap on what we discussed in the morning. The morning we discussed the first step of the forensic investigation process. We discussed the preliminary review, the pre-engagement investigation. We saw the importance, or rather we discussed the importance of the preliminary review because it gives the investigators better understanding of the environment within which they are going to operate as investigators, the extent of the fraud or corruption allegation, the questions as to whether the investigators will require traveling up country or throughout the country visiting various branches, was answered during this pre-engagement review or pre-engagement investigation. We also noted that the costs for pre-engagement investigation must be borne, must be carried or absorbed by the investigator, because it goes a long way in saving him a lot of trouble. Because going into an investigation without better understanding of the nature of the allegation and the complexities of the client environment will cause more trouble and even lead to more problems and more costs. This evening, we are going to discuss step number 2 and 3. Step number 2 is engagement letter or contract. This follows the pre-engagement investigation. We will only come to number 2 if we have decided that we are capable of carrying out the investigation to the satisfaction of the client and to the highest professional standards, so that no one will come to accuse us of anything. By this time, we have decided, the investigator has decided that is going to complete the investigation, whether it involves in-country operations or overseas operations. Then we will move to number 3, planning and resource allocation. This means that this lecture may take longer, may take a maximum of 1 hour, because we have to discuss the 2 steps in the forensic investigation process. I will start with the engagement contract. I've already mentioned that the engagement contract will follow the pre-engagement investigation. By this time, we know what is required. We know the objectives of the client. We know we have the rough estimate of the costs that will be involved. We know the extent of the investigation. We know whether we need specialized experts like the digital forensics experts. We know and we are prepared where to get them from. We have already estimated how much each expert will cost us, because we already have the estimate of the number of such special experts to use on the investigation. We know the estimate of the general investigative staff, the number of the investigative staff to use. We know how far we will be required to travel. We understand all these things from the pre-engagement investigation. And therefore, when we come down to the engagement contract or engagement letter, we are going to be able to give a quote that will be not over or under, that will exactly compensate us for our costs and get some markup. Because as investigators, you are an investigator. As an investigator, you are in business. You cannot carry out an assignment just to break even. You have to remain with some margin. The engagement contract is a written document that is signed by both the client and the investigating firm or the principal investigator. The engagement contract is usually drafted, discussed with the client, and agreed before signing. The person who drafts the engagement letter is the service provider, that is the principal investigator, representing an forensic investigation service firm. Immediately, the engagement letter is drafted by the principal investigator. It has to be discussed with the client so that there is an agreement and mutual understanding on what is included in the engagement letter before it is signed. The engagement letter will outline various items, including the terms of reference. Terms of reference will be given by the client and discussed and agreed with the principal investigator representing the investigation services firm. The terms of reference will indicate the scope of the investigation. Within the terms of reference, it will be indicated how many branches will be visited by the investigators, and they will be mentioned by name, branch names or branch numbers. If the investigation team will be required to carry out overseas operations, then the countries and the locations outside the client's country will also be mentioned, because this will be included in the terms of reference and the scope of the investigation. That is number one. item number 1, that will be indicated in the uh, engagement contract. Number 2 will be the compensation terms and reporting timelines, deadlines, and these will include the basic compensation, including some expense reimbursements. This is why the knowledge of the scope, the complexity of the investigation assignment, this is where it helps, because without knowing whether you'll be traveling widely or outside the country, you cannot be able to come up with a proper estimate of the compensation. Compensation will be proposed by the investigating firm or the principal investigator and will be discussed or negotiated with the client or the person representing the client, who is usually the chief executive officer, and then the amount agreed will be put in the engagement contract or the engagement letter, including the agreed expense reimbursements, which will be additional to the basic compensation agreed. Under this number, the timelines for reporting to the client will be agreed. The timelines for completing, for example, submitting the first draft report, something like that, when to complete the investigation, when the investigator, the investigating team is expected to deliver the final report to the client, something like that. Then number 3, the person hiring, the name of the person hiring the investigation team, and therefore the authority to report to. If the engagement contract or letter is signed by the chief executive officer, then it means the hiring authority is the chief executive officer on behalf of the board, and therefore the investigation team will be reporting to the chief executive officer. If they want anything, if they have any challenges, they will be channeling their queries and all their challenges through the chief executive officer, the CEO. And this must be clearly indicated in the engagement letter. Number 4, agreement as to the procedure for reviewing a draft report with the client before the final report is reached. There must be an agreed procedure and the number of drafts that can be reviewed by the client before the final report is reached. Ordinarily, you will find that the draft reports will be 2. The initial draft report that will be issued to the client, and then he would go through it and send it back with comments, and then the investigative team will update the same report and they come up with a second investigation draft report, which will also go to the client. He will go through it and send it back with some comments, and then the investigative team, being led by the principal investigator, will go through it, complete the areas remaining, and then come up with the final report that will be printed and delivered to the client, and that will end the investigation. Number 5, agreement as to time and the cost escalation at the request of the client or due to a situation or happening precipitated by the client or her staff. The investigator, the principal investigator of the investigating team, might also wish to indicate that if something crops up that was not unforeseen, they might ask for some extension of time and also the cost escalation. This can be controversial because clients will not like this, do not like this one. They do not like investigators who in the in the middle of the investigation process will come back and say, oh, we did undercharge, we did do this and that, so we need more time, we need more payment. The clients do not like this kind of thing. That is why we said in the pre-engagement review that you must come up with another a good understanding of the client requirements, and therefore give a quote that will cover everything. And when you sit down to agree with the completion timelines, you know you are doing that with finality. You are not going to come back and ask for more time. The cost escalation clause is therefore mainly for the client, because the client has got the flexibility to ask you to carry out more tests, more investigation tests. And if you do that and it was not initially agreed, then you must sit down to a negotiation. And this negotiation may result in time extension and also more cash to the investigation team. Number 6, dispute resolution procedures. Dispute may arise. Dispute may arise um, from either party to the engagement. The investigation team may raise some dispute, or the client may raise the dispute. So within the contract agreement, the contract document, the both parties must agree how such dispute should be resolved. The agreed dispute resolution mechanism, if followed, settlements may be arrived at professionally without going to the courts of law. The purpose of the engagement contract. The engagement contract sets the boundaries and the responsibilities of the investigation team, and it also protects the investigation team in case the client raises some dispute for some work not done. If that work was not covered within the scope of the engagement as per the contract, then they will not have any case. But if the investigation team did not carry out all the tasks, or did not go cover the scope outlined in the engagement contract, then they can be in for it. So it protects both the client and the investigation team. I will now give you a quote from Karagiosis 2005. It also acts as a firm foundation upon which the client communication and the trust are based. Whilst your authority may require the use of engagement letters, it should be a must in your practice or guidelines. According to a recent article by the ABA Standing Committee on Lawyers' Professional Liability, at least 16% of all claims had been caused by poor client communication and consultations. This case equally apply in forensic investigations. Amongst the things that should be included in an engagement letter include the client details, subject matter, scope and objectives of the investigation. Reflection ought to be given to a requirement on what you would not do for the client in question, particularly in situations where similar facts give rise to recoveries on multiple theories and explanations. Furthermore, consideration must be given to set forth any problems or complications or even the weaknesses that have already been realized and any special agreements concerning the inquiry. However, the investigator must never guarantee specific results, such as amount of currency in the contract letter. This means that in the contract letter, the engagement team is not supposed to say that through their investigation, they are going to recover a certain amount of money or a guarantee that they will recover $2 million, for example. That is against professional practice in forensic investigation. Should the client require that one promise a specific outcome of the investigation, then the investigator must resist such attempts discreetly, since an investigation is an inquiry that may lead to any result, recovery or not. Deadline for such investigations must be agreed upon by client, and the client must commit himself to facilitate the investigation by providing all required explanations, documents, and other items that may be required for the purposes of the investigation. All of this must be clearly recorded on the engagement letter or contract. The number of times in reviewing the draft report must be agreed with the client and all details put in the engagement letter. Typically, the report drafted must be reviewed twice and then final report is submitted to the client. I will now discuss briefly the types of forensic investigation engagements, short-term engagement or long-term engagement. This may either be external or internal engagements. If the engagement is going to be for a short and fixed time, then it has to be clearly stated in the contract. If it is going to run for in the long term, then that also must be indicated in the contract. Forensic audit or investigation is an investigative activity undertaken by an independent forensic practitioner, a certified forensic investigator, to provide opinion to a principal, the shareholders, over subject matter, financial statements, which is the primary responsibility of another person, directors, against a given criteria or framework, whether any financial wrongdoing occurred or not. Forensic investigation or audit. Forensic investigation combines the use of investigative skills to situations that may involve legal and results. Forensic investigations are usually carried out in instances like the ones below. This deception investigation involving misappropriation of funds alongside tax evasion, money laundering, and insider trading. Qualification of loss in case of insurance claims. Establishing the profit share of business partners in case of a dispute. That was, by the way. Let us now look at the come back to look at the significance of having a scope, the scope of the investigation clearly stated in the engagement letter. The scope of the investigation, as agreed with the client, is what will determine the costs that will be involved. The expenditures by the investigation team will be dictated by the scope of the work to be done. This is the end of the discussion on the engagement contract. We have already noted that the engagement contract must be signed by the two parties, the client and the investigation team, and each of them will keep a copy in the case of anything in the future or as they carry on the investigation. I will now move to planning and resource allocation. Once you are done with the engagement, you move to step number 3, which will involve the planning and resource allocation. You cannot just sign an engagement and then you move into the client business premises to start investigation. That will be poor attack on the investigation process. You must sit down to plan. And the planning will involve assignment of tasks or to each and every person that is required to carry them out, and then give them deadlines within which they must complete the tasks allocated to them, so that they do not affect the overall deadline of the for the completion of the investigation assignment in its entirety. Here you will use the information you gathered during the pre-engagement investigation. By now, you understand many things about the engagement, the investigation assignment. You know the number of special experts to use, so you have to recruit them and assign them the special tasks to carry out and give them the deadlines within which they have to complete that and submit a report to the principal investigator for the compilation of the overall report. You know how many staff to use on the general investigative process, and therefore you need to assemble the team, give them equipments. They will need equipments like computers, they will need communication gadgets, they will need storage gadgets, and etc. This must be procured, the number must be identified, procured, and then assigned to each and every individual that will be using them in completing the required assignments or tasks. If traveling is required, we must, during this, as an investigation team, we must, during this planning and resource allocation, ensure that we have enough number of cars to be used. If private cars are to be used, then we must know the number of the cars to be used, and then this must be allocated to the investigating sub-teams to use. If traveling outside the country is required, We must plan for the air tickets, accommodation, everything. We must know who is to be involved in the overseas operations, and then assign them the tasks to carry out. You cannot carry out overseas operations without having some local experts to advise you, because investigators usually face cultural problems when you go to different countries. So you have to have some local experts who will guide you on such things. I will give you a very practical example. When you go to the country like Pakistan, for example, when you turn your head sideways and you are in the middle of a discussion, it means that you are saying no. When you do it like this sideways, you are saying no. So if you don't know and you do not have someone to guide you, you might think that this person uh, is I'm sorry. When they turn their head sideways like this, they are agreeing. They are agreeing to you. But when they do it like this one, they are disagreeing. They are disagreeing. So it is completely an opposite direction from us in Africa. When you do this way, you are saying no. But for them, when you are doing your head this way, you are saying yes. When you are doing it this way, you are saying no. And in Africa, when you do it like this, you are agreeing. You are saying yes. So you need some local experts to arrange for them and allocate each one of them to the overseas operations sub teams, so that they will be guiding them on the cultural whatever local practices that may hinder their correction of evidence. Or this must be discussed and agreed within the planning and allocation process, resource allocation step. That is step number 3. It is important for the success of the investigation. The objectives of the investigation must be looked into at this stage, and then the investigation team comes up with a clear approach of attack on the investigation. Clear approach on the attack on the investigation. Where to start, which branch to start from. Are we starting with several teams working at random, teams working abroad, teams working at various branches at the same time? Or we are going to start with a few branches. Once we are through, we go to the others, just like that. We have to agree the approach of the attack on the investigation. On this step number 3. Step number 3 is very important, because if we do not plan well and allocate resources well, we automatically plan to fail, and we will fail flat. We will fail badly. So this is where an investigation is, I can say, is succeeds. It succeeds from the planning stage. If we plan well, we succeed. If we do not plan well and allocate resources well, we fail. Because if we do not plan well and allocate resources well, we might even overspend. Complete the investigation perfectly, but we find that we have spent resources, and therefore we have done something like nothing as far as our pockets will be concerned as investigators. So we have to really sit down to do the planning so that we have optimum allocation of resources. When we are assembling the investigation team, we must look at various expertise required, because from the pre-engagement investigation, we already know the expertise we need to complete the investigation. If the investigation or the allegation of the wrongdoing goes as far as touching on personnel records, payroll records, we need to have even the HR experts in our team. We need to have computer and digital forensic experts in our team. The legal counsel cannot miss, because this is the person who will be guiding us through and advising us on the privileges and rights of suspects and witnesses, so that we do not trample underfoot. Sorry. So that we do not trample underfoot the rights and the privileges of the suspects and witnesses, and therefore shoot ourselves down. Because if it is proved in a court of law that we corrected evidence ruthlessly, trampling upon anyone who came, who stood against our way, then we are not going to succeed. Professionals do not work like bulldozers, trampling upon anything within their way. You work professionally. You work with people who volunteer. You respect people. You respect their privileges and rights throughout the correction of evidence, and even during interviews. You do not pinch, you do not punch, you do not press. You see, you do not inflict any pain on anyone in order to extract information. All these will be guided or will be advised by the legal counsel. We need the cooperation of company management. They must be informed that they are included in the investigation team. Someone must be appointed who will be maybe will be like a bridge between the investigation team and the management team, so that the flow of information is perfect, and therefore there will be no delays in the investigation. During the planning, we must consider the motive, opportunity, and the means that enabled the allegation to take place. We must consider this, and then we must determine some of the alibis of some of the suspects from our initial investigations, and then get prepared on how to attack them during the main interviewing stage. During this planning stage, we must also come up with a good plan how to do the labeling of the evidence collected. The physical evidences must be labeled during the correction, must be preserved. We must make sure that we have the gloves so that we do not touch the documents unnecessarily. Gloves must be purchased. We must know how many of them will be required, and then they will be purchased for the purpose of preserving the integrity of the evidential documents or the exhibits corrected. Doctors use the gloves to prevent diseases from uh, uh, spreading from the patients to them. But investigators use gloves to prevent contamination coming from them to the exhibits. You need not to put your fingerprints on the exhibits unnecessarily, because that will interfere with the further forensic analysis, like fingerprints analysis, handwriting analysis. If you touch the documents unnecessarily, then these will interfere. So at this stage, the investigators or the investigating team must also come up with a very good structure of the chain of custody. The chain of custody is a very important document which must be procured and put ready or assigned to someone to be keeping it right away from the beginning, from the correction of the first evidential document or evidential item. The chain of custody will be discussed later on under, hold on a minute, will be discussed later on and under step number 5, documents examination, documents examination and correction of evidence, including the fraud stroke corruption risk assessment. This is where the chain of custody will be discussed in details. But at this stage, I'm just saying that this is a very important document which must be procured at this stage of planning and resource allocation, so that this lady, when the investigation teams start the investigation, start correcting the first items of evidence, they start entering that chain of custody. It is required. It must be done systematically, and it must be shown that it was done systematically, and the documents were well preserved by the investigators. I would, at this stage, touch on forensic investigation logbook. It is very important. This must also be procured at this stage for use by the investigative teams. Plan to produce a forensic investigation logbook for keeping the information collected by the forensic investigative teams. The investigator may wish to have individual team members initiate their work to see to it that each member is contributing to the investigation process. The principal investigator may choose to allow the team to access this information at any time, even during the final examination. Investigators are encouraged to keep their database or logbooks neat to organize the information in a manner that allows them to retrieve information speedily. It appears that I've really rushed through the 2 steps of forensic investigation process. I've come to the end of the discussion on step number 3, planning and resource allocation. This brings us to the end of this evening's lecture, and since I can't see anyone raising any comment or question, I beg to hang up. Thank you very much for listening, and bye-bye. Until tomorrow morning at 7 a.m. our time, when I will take you through step number 4. Step number 4, I will take you through step number 4. Step number 4 is preparation of the suspects and the witnesses rough lists. I will take you through that, and most probably I also touch on step number 5, documents examination. Thank you very much, and bye bye.